Well, let's see if we can get Gus on here. I was saying that maybe it was about 3 months ago, of all places, I found this amazing article in Westchester magazine. And it was about 50-50 not necessarily being best for kids in certain types of situation. Here he is. Okay, Gus, I see you. Let me see if I could get you on here. Of course, now I'm pressing the button and it's not working. 1 second. Oh my gosh. I don't know what is happening with the technology with Instagram today. It's crazy. Let me take off my screen. Okay. Here. Sorry, guys. Hopefully Gus can get on here. And it works.
I promise you, Lisa, I'm a better lawyer than I am a tech guy.
Okay, good. I don't think this was your fault, Gus. But anyway, I was saying that I saw this incredible article that you had written called The Equality Trap in Westchester magazine. And it got a lot of controversial comments about it because, in general, I think most people in many of the states think, well, why wouldn't we do just shared custody, shared physical if possible, shared legal custody? Before you even officially introduce yourself, how are custody arrangements different than 30 years ago?
Well, look, society is different than it was 30 years ago, right? Traditional roles of males and females were different 30 years ago. But I think the biggest difference is basically the way the courts are looking at the issue. I don't know exactly how the evolution got there in terms of the courts. Was society following the courts, or was the courts following society's changes? But courts are now really starting to implement this as if it's a default and it's a problem.
Okay. So before we go on, tell people who you are and a little bit about your background.
Sure. My name is Gus Dimopoulos. I'm the managing partner of Dimopoulos Law Firm. I'm exclusively a matrimonial attorney. I deal with very complex, high conflict cases. My practice is in Westchester County and New York City. And, what your content is what I'm seeing, every day in people finding a very difficult time sorting their matters out in the courts. It's a real problem.
Yeah. Are there certain mistakes or misconceptions that you see happening often when people first come to you regarding their ideas about how custody is going to be?
I think people have a very unrealistic view of the court system itself, and I think, if you read the scholarly articles and you follow content online, you read blogs, the one thing that's really missing from the education of people as they start to navigate this process, both before, during, and after, is no one is giving people a realistic view of what it's like in court. And sadly, I don't think lawyers are giving their own clients a realistic view of what does this particular judge tend to do? How are these concepts viewed in the court system? If I make this argument, how's that going to go? And just in general, Lisa, how stressful and difficult the court process is when we say we're litigating. What does that mean? What does it look like? How long am I going to be in court for? How long is this appearance? What is the judge? Is the judge going to ask me any questions? Are we just talking about this topic, or can another topic come up? It is a fourth dimension, and people need a better education of what it's going to be like.
Yeah, what you're talking about, actually, I told you that we just went to the AFCC conference, and there's a man, I'm not sure if you're familiar with him. He's a psychologist named Dr. Ben Garber, and he's written a whole bunch of books. But we actually wrote a chapter for his next book that's for the Bar Association coming out in 2027 about a concept he developed called advance orientation, which basically means that most people would do better if they understood, they were educated about what to expect in family court, because it would reduce the level of fear. And when people are educated and not ignorant, they understand what's expected of them, things make sense, and everything, the fear, everybody does better when we're not afraid, because we know we cannot make decisions, good decisions, in this emotional upheaval state.
And what about, I agree 100%. What about when people aren't informed that a temporary or interim custody provision can be implemented in court, in the middle of the day with 15 minutes left before the court breaks for lunch, and the judge tells you, go outside and work it out, and if you don't, I'm going to rule on it. People are not told that that's even a possibility. Um, People are asked to negotiate important parts of custody agreements without ever having read what a custody agreement looks like, what the options in the language can be, putting aside what the courthouse looks like, where they should sit, what they should wear, how they should behave. Anyone that's ever been through it, I did an episode actually on my podcast with a former client of mine. And one of the things I asked her was, what was the biggest surprise for you? And she said, how the court operates. I mean, waiting around, then you get called. The judge doesn't even know anything about your case or your names. And then so I think people, and it bleeds into the conversation about 50-50 because people walk into court kind of not understanding what the court's view of it is and how they're going to. So it's another unexpected event that comes up in their court appearance.
Yeah. One thing that we see all the time with the people we work with is the sense that if there's been abuse against me, one of a spouse, that's going to make it easier for me to have more primary physical custody of the kids.
Sometimes it is, and sometimes it's not. I mean,
Right.
again, I can't imagine being a victim of abuse and making that argument or putting forth that position and someone disagreeing. But look, people need to understand that, and I say this to people all the time, you follow in the footsteps of thousands of others. So if you're, and again, to use traditional statements, if you're a man who yelled and screamed, right, on one occasion and only one occasion, and you take responsibility for it, and you're sorry it happened, but there's not a history of it, you follow in the footsteps of 1,000 other men who have been abusive and who have behaved in that way. So you're automatically labeled. Same goes for.
Oh, wait a sec, Gus, you're frozen. Uh-oh. Go like this.
I apologize.
It's okay. Okay, say that again. So you talked about men following in the footsteps
Right.
and being labeled, and then
So if you make an allegation of abuse and you're a female, okay, again, to fall into gender roles a little bit, you know the court is looking at you, judging you from the experience it's had in hundreds of other cases, and perhaps in some of those cases the abuse was overstated or not exactly accurate. So people come into court expecting to be believed because that's
Mhm.
what happened to them. And they know that's what happened to them, but their audience, the judge, is looking at them skeptically, perhaps. And it's hard for people, especially people who've been victims of real abuse, to be looked at skeptically because it takes enough for them to come out and say it to friends and family. It takes an entirely different set of guts to say it in court with a court reporter. And the last thing they're expecting is, well, did that really happen or are you over exaggerating? So again, we have to remember when you go to court, you're not the first person that ever appeared before that judge. You are being judged based upon his or her prior experiences.
Right. And I think another thing people have such a hard time is the judge probably is skeptical because, well, I'll just ask you this, how common is it for people to lie? And
You
how
want
how
you
often
you
do you
want
see false
you
allegations made against another person during a custody battle?
look, people lie in divorce all the time.
Yeah.
They lie about small things and big things alike. Um, how often do I see false allegations of abuse? I don't see them very often myself, um, because I think I have the benefit of vetting the cases that I take.
Mm,
Um, and if I, in my intake process, don't find someone to be credible for whatever reason, then that's not a case that I take.
mhm.
So now, how often do I see it coming from the other side? Less often than people think. I don't think people invent abuse. I don't think it is something that, if you look at the statistics and look at the studies, it really isn't something that someone lies about. And I don't mean, do they have marks? Do they this? I find that it's incredibly embarrassing for people to, how I see it often enough where people have been abused but don't want to say it. So it's an embarrassing thing. It's incredibly difficult for someone to admit to having been a victim of it. So I think I fall into the camp where I don't think when it comes to true abuse, people are over exaggerating or lying about it. Have I seen it? Absolutely. But it's pretty surprisingly easy to spot. Um,
Interesting. Because well, maybe it's because of the community that we work with, we see it a lot. And yeah, it's very hard. Have you heard of something called the silver bullet technique?
no.
Oh, okay. So this is like a thing that's been happening for a while. It's usually focused on women who are being told by certain legal professionals that if they file a restraining order against their ex at the very beginning of the process, that and get the restraining order, that it'll give them a leg up in custody.
Oh, okay. I didn't realize it had a name, but I really
Yeah.
like it. Look, let me tell you this much, and I'll give you anonymized, obviously, a story that
Mhm.
happened recently. Okay. I think jumping to that step is, there are certain instances where it has to be done. Let's not kid around. People, we all read the stories. People can hurt each other. People can kill each other. Okay,
Mhm.
I'm not talking about those scenarios. There are other scenarios where, again, people are trying to weaponize the temporary order of protection. They know that more often than not, these allegations are rubber stamped. Temporary order of protection is given, and they have the leg up. I've seen it in a recent case. um, Someone did that. Okay, it happened to be mom. And when I read it, it was so patently absurd
Mhm.
and so obviously false that, we decided to ask the court for a hearing. And when she finally got a lawyer, the lawyer said, "Hey, listen, I think we could resolve this. I think we can, I think we could just forget about the temporary order of protection as long as you give my client exclusive occupancy." And I told the guy, I said, "Hell no. Let her take the stand. She swore to those allegations. Now let her testify about them and be subject to cross examination because my client hasn't seen his children in 13 days. So we're going to do this." And she was almost entirely proven to be not credible. The judge issued a ruling from the bench, um, claiming that she didn't sustain her burden, that he found it to be, he didn't use any, strong words, but he dismissed the entire thing. Now, think about the rest of her custody case. She has been proven to be a liar. She has shown to be someone who is perfectly willing, capable, and able to have the father of her children not see the children for 11 days. She labeled him all sorts of horrible things, okay, and lost. How do you think her custody case is going to go forward when the court is analyzing, can she foster the relationship with the other parent? Can she be credible? Can she follow directions and orders? She's basically ruined her entire case on day one because
Mhm.
she didn't think through that initial step. So the silver bullet offense, so to speak, could be the most disastrous thing in your case if it's done under the wrong circumstances.
Yeah, I totally agree. I also think about the impact that starting a case off, just throwing fire onto a conflict. It doesn't just affect the divorce, it affects your family's situation and your children's lives for a long, long time,
Yeah.
right?
And how about the fact that that temporary order of protection has to go to your kid's school, right?
Hmm.
So now the principal, the guidance counselor, the school therapist, you know, everyone knows about it. So look, there are circumstances where people are in real danger, and no one's talking about those circumstances. And then there are circumstances where people are weaponizing certain tools that are available to them. And the bottom line is, anyone that does it wrongfully truly isn't thinking about, how do I resolve this case with the least effect on my children? That's the last thing on their minds.
Yeah. So speaking of that, I think you and I are aligned in terms of wanting to make sure the kids get through this as healthy and unscathed as possible, that families get through it like that too. What is this equality trap? Tell us about, what you were talking about in the article.
Look, I've been practicing for 25 years, and I've seen the evolution of this concept that I call the equality trap happen over time, which is basically, and I'll start with how it comes out in court, and then I'll talk a little bit about how kind of the research has gotten us there. But in essence, look, people need to understand that judges have hundreds of cases on their dockets, hundreds. Sometimes they have 150. I've seen it go up as high as close to 300. That means 300 cases, 600 lawyers, court appearances, and they only have 6 hours a day with a lunch break and a 4:30 break to resolve all these cases. So what is the one thing that makes divorce litigation more difficult than anything else? It's litigation over custody, right? And judges say it right off the bat. I don't care about money. You guys could argue about whether it's 50%, 40%, whether maintenance should be 10,000 or 7,000. I care about the kids and I want to resolve custody, right? So if we approach the issue with the understanding that judges, for the sake of their docket, for the sake of humanity and for their emotions, don't want to preside over custody cases because it's difficult. What is their first goal? Their first goal is to resolve cases in settlement and do it early, right? Coming to the issue from that perspective, what is the fairest thing to do when two people are arguing about anything, right? We have kids, right? You brought two brothers fighting over something, guys, just split it, right?
Hmm.
6 slices of pizza, both people are hungry, you take three, right? That concept of equality and that certain view of fairness looks good on paper with custody, but it's disastrous in practice oftentimes. And what happens is people come into court, and if, again, going back into our gender roles, dad says, yeah, I want a 50-50. Judge is going to look over at mom and say, sounds great, why not? And that in that little moment, we're beginning to see that there's this presumption occurring in the court, a presumption of 50-50. And when we talk about presumption in a legal standpoint, Lisa, we have to understand that there are certain presumptions in the law, and there are guidelines, and there are things that the court starts from, right? Um, Custody and 50-50 is not one of them. What people don't know is that this particular issue and whether or not there should be a presumption of shared equal custody in the law has been before the New York State legislature for 25 years. And every time it gets proposed that New York should follow a presumption of shared custody, it never even gets to a vote. It has never even gotten that far in the legislative process. So New York's legislature has told the courts, told everyone, this is not a presumption.
Mm.
We have zero presumption. Other states do. And I think Kentucky does. I can't remember what the other ones are, but they have a presumption that when you walk into court, it is presumed that we start there, and now you have to show us why you shouldn't be there. Whereas in New York, it's the best interest analysis, and there are no presumptions, and then you have to show us what we should do. So that's a really important legal nuance that people need to understand. So are judges now legislating? Are they now creating uh, their own legislation from the judicial branch? Not to get nerdy, they can't do that. They have to follow the law. And the law says you have to do a best interest analysis. Here are the factors you have to consider. And then you have to tell us what you think is in the best interest of the children. I find more often than not, they're not exactly doing that. So that's where the concept from in court began to arise. From a research perspective, from an academic perspective, I think it has much more to do with the changing roles of gender. I think a father's view of parenting from the 1960s to now is vastly different. I think dads are getting much more involved in their children's lives and in parenting than they ever were. And more often than not, that's an incredibly amazing thing. But when litigants who really truly shouldn't have a 50-50 or can't have a 50-50, when they begin to take advantage of this growing presumption to get what they want because that's their own view of how I can be an equal parent, and he or she's not going to tell me that I only get this amount of time. In none of those conversations, Lisa, did either of those people ever say, let me sit long and hard and think, does this work for the kids?
Hmm.
You know, is this doable? Is it possible? Do I want to pick my kids up from school on a Wednesday morning with backpacks loaded, baseball gear? One kid's got a therapist, another kid's got a dentist. I don't get out of work till 5 o'clock. I got to have the au pair pick him up from there. And then we got to do that all again a second time during the week. So I'm not here to say that it doesn't work. It works exceptionally well in many circumstances, and it's a disaster in others. And all I'm trying to say by writing the article and trying to educate people is, how about we actually think whether or not your facts, your kids, your life fit into that scenario versus taking that scenario and jamming it upon a family where it doesn't work.
Yeah. As you're saying that, I'm thinking, especially coming back from that conference, about the impact it has on kids when there is still a lot of conflict between the two parents post divorce. Why, or what are your thoughts on that? When, because, for a lot of cases, ours, the anger doesn't subside.
No,
So the kids are going back and forth, but there's tremendous stress still between the parents, and the kids are exposed to that regularly in 50-50 cases.
look, what are we told from when we are kids about, a kid is having a difficult time with another kid in school, or a bully? We say, just stay away from them, right? Like, the concept of when you have conflict with someone, the thought of bringing those two people together more often is just the dumbest thing I've ever heard. We have to craft situations in high conflict situations where two people see less of each other, but they still have to fashion some type of a custody arrangement that works. So a 50-50 arrangement, what people don't understand, what I try to explain to people is, let's play it out. Do you understand what that means? Because it sounds great, sounds lovely, okay? But here's how it actually works. Your kids get out of school at 3 o'clock. Where are you at 3 o'clock? Oh, you're in the city at your desk? Okay, great. Who's picking them up? Can you leave work that early? And if you can, do you then have a conference call at 4:30 because your kid has to be in two different places? Okay, so that's one practical element to it. The conflict situation that you're talking about is, there is so much coordination, Lisa, that anybody that knows, has kids, understands. When in dealing with children's lives, coordination meaning, okay, Sally has a softball practice, but she doesn't feel well. Her tooth hurts. Can I call to make a dentist appointment, and can we switch to softball practice? No, she's going to softball. I don't agree with that. So the level of coordination that an equal parenting schedule requires works exceptionally well for two people that communicate and get along to the best of their ability. Let's not forget, they're getting divorced, right? We don't need to be best friends. We need them to be loving and equal co-parents, right? They can communicate their way out of any situation. Oh crap, I forgot. Can you? Sure, I got you. Don't forget again, right?
Yeah, that doesn't happen with any of our clients.
No, that's not even, in some of the cases that I see, it's, I'm so happy they forgot, little Johnny at practice. Now I could use that as evidence as to why they should or shouldn't this. So they're almost throwing banana peels in front of each other to prove that they're the better parent. So again, a 50-50 scenario requires coordination, communication, and a level of, mutual respect for each other's time and schedules that high conflict people just don't have.
Hmm. So what happens? Like, what do you suggest? We mentioned off camera, Carl Knickerbocker, Unapologetic Parenting, here on Instagram. He wrote a book about parallel parenting. What is parallel parenting, and how does that play into this notion of 50-50?
Look, parallel parenting at its core is trying to figure out how two people who cannot get along and who argue and scream and fight all the time, whether it's one person's fault 80% of the time, the other person's 20% of the time, it's equal, or it's whatever it is. And how do we get these two people to parent their children by going in one direction together, always, what's best for the kids, but having as little to do with each other as possible, right? So you do this, I do that. You go to this, I'll go to that. It's keep each other out of, each other's way in parenting. People talk about spheres of influence, right? So we don't have to argue about, extracurriculars. That's your domain. So we don't have to argue about education. That's my domain. In essence, that's the concept of parallel parenting. And it's also just a way to teach people. If you read Knickerbocker's book, I think it's really good. It's don't engage. Don't think that if you just write that text, he's going to get it or she's going to get it. They're not going to get it. That text is just another, whatever chemical is firing away at our brain that causes us to further engage. So that's the concept. We need to do what's best for our kids. You and I can't be civilized to each other. So let's run in parallel to get what it is. The problem with parallel parenting as a concept and a 50-50 is, let's face it, there is a level of coordination that is required to raise children in 2026 that simply wasn't present 30 years ago, 40 years ago. And not to get present, but whoever your listeners are, kids are involved in enrichment activities, tutoring, extracurriculars, sports, club sports in a way they never were. I'm 50. When I was a kid, soccer practice was down the block. I walked there. I came home. I went home. I didn't have all these other activities. And I'm sure many of us who are around the same age, it's just the way we as a society parent children now, where kids are doing a lot of stuff. So when you introduce a lot of stuff to a kid's life, it requires coordination. And in any situation, can it be done? Sure. But it invites two people who are in high conflict situations to constantly have to coordinate. And it invites fighting and conflict in a way that another situation doesn't.
Yeah. And as you're mentioning that, this is making me think about one of the programs that we just saw at that conference, which talked about something you said where there's an event, both parents would switch off. So there wouldn't be an event where both parents are there in a high conflict situation. And social work was talking about the impact it has on a child who sees two parents in conflict at let's say their game, where they're so consumed with, oh my gosh, how am I going to navigate who to talk to or not, or one's going to be mad at me if I sit with that one, that they can't even focus on what they're doing.
From a practical standpoint, your daughter plays soccer. She's in fourth grade. I'm making this up.
Mm-hmm.
She scores the game-winning goal. Mom's over there. Dad's over there. Where does she go to celebrate?
Right.
Let that one soak in for a minute, right? That kid is super torn. And she's worried about if she goes to mom, how dad will feel. If she goes to dad, how mom will feel. So that's a extreme example of, yes, if you stay, if it is so bad that you have to stay away from each other's events, fine. But perhaps another scenario where two people literally, because of their, I won't say words, because they can't be next to each other, then perhaps one person doesn't go. Do it for the kid, right? Do it so that the kid doesn't have that conflict, knowing you can't be together. That's your problem, that you and your spouse can't be together. Don't make it the kid's problem. So perhaps dad goes to games on Saturdays, mom goes to games on Sundays. Again, this is coming from a child-centric standpoint where, on the one hand, you say, what would be better for my kid? On the other perspective, you say, who is she to tell me I can't go to games? I'm going to go.
Mm-hmm.
Right. So you can't teach people this, but what you can say to them is, listen, what I just said to you, don't make your kid feel that way. So I think this is a good system to implement. And perhaps you break through to someone.
Yeah. Yeah. So what was I going to say? I lost my train of thought. Yeah. But speaking of that, let's say there's a parenting plan, an agreement's already been made, and it doesn't say that parents should be separate at, let's say, a soccer game. The parents are supposed to be respectful toward each other, but I'm thinking of a particular client of ours where the ex comes and sits right behind, and the kids are turning around going, why are you sitting near us? You know how, and then the other parent is getting visibly uncomfortable, moving away, and the other one keeps following them. Like, what can someone do if they have an agreement which doesn't explicitly say let's take turns, and the other parent won't listen because they love making our client extraordinarily uncomfortable, as well as the kids. They don't care about the kids.
Listen, first of all, let me argue it from two perspectives, right? From the first perspective, and I think this is really super important for your listeners. Everybody wants to settle custody and everyone wants to get out of court if they can. And sometimes they are willing to agree to things that they really don't want to agree to for the sake of not having to go through, whether it's financial, emotional, psychological, or whatever. The problem is that you have to live by that agreement. So you have to take into consideration practicalities such as the one that you just said, right? So if because in haste to settle, that mom said, all right, I'm not going to argue with him that he can't come to games, then she's going to have to live with it, right? So the one thing I would say is please list the 5 or 6 things that really are a problem in your relationship, right? And deal with them in the agreement.
Mm-hmm.
So whatever those things are, and everyone has different things, right? You can't speak to me in this tone in text. Put that in the agreement, right? Oh, we shall have cordial conversations. No, don't use this type of language. Don't be specific. If you're going to come to a game, don't. So you can put as much level of specificity in an agreement that you can. Now, let me argue from the other perspective. You make that same argument in court before a judge at a settlement conference. I'm representing mom who feels uncomfortable when dad sits near, right? I make that argument. I'd like to insert a clause that says, and the judge turns to you and go, are you kidding me? You guys were married for 17 years. You can't sit the same ballpark with them, right? So I'm not belittling the person that didn't add it because sometimes you get laughed at, okay?
Mm-hmm.
What people have to realize is that they have to say in those circumstances, absolutely, judge, and let me give you 3 reasons why,
Mm.
okay? What your listeners need to understand about custody litigation in general, but specifically as it relates to 50-50 in custody is the mistake people make is speaking in these dramatic fashions. So let's just take perspective of a 50-50 from let's use this example, moms, okay? Mom either works part-time or was a stay-at-home. She's done everything for the kids for their entire lives. Dad was working 9 to 5, 9 to 7, and all of a sudden he wants 50-50. Bad lawyering, bad legal strategy is that person comes into court and says, oh, please, he's doing this to torture me. When we were married, he never wanted to be with the kids. Opposing counsel's argument, almost knee jerk, is isn't it wonderful, Judge, that my client is now prioritizing his children and has decided to make a change to be around more for his kids? Oh, and incidentally, he's earning 30% less. So when we talk about child support, we'll get into that too. So you've lost that argument. Instead, come to court with a pragmatic list of why it doesn't work. Instead of being dramatic and derogatory, say, okay, Judge, I actually made a list of the last 9 months before we were divorced. These are the following business trips he went on. He went to Austin, Texas for this amount of time. He's got this, he's got that, he's got that. Also, here are the work policies. I think it's great that he's working. I appreciate it. However, if he can't be here and can't be here and can't be here and can't be here, how are we going to do this? Courts then will say, she has a reason. She's thinking this through. She's doing it for the kids and not because she just doesn't want dad to have what he wants. On the court, on the reverse side, if you are the traditional man that was working, show us a copy of the policy from your employer that says, oh no, they understand I'm going through a divorce. They're going to make time for me. I've got to show us how it's going to be done. Tell us what the train schedule is and what time it gets you into the local train station to show that you've given this some thought. Let us know what you're going to do when there is a work conflict. Who's going to, so again, facts, evidence, and reasoning that are child centric, no drama and histrionics, you're going to lose.
Yep. I love what you're saying. We say we want our clients to come in as the proactive problem solvers.
100%.
Here's what's happened. Here's how we could make it work. And here's another way we might be able to make it work. but how are we going to do it? And then let the other person come in with their ideas too. So it's not like you're coming in as the authority and dictating how it has to be.
Look, judges, by and large, they're smart people. Okay, they didn't become a judge because they're not smart, and they're also experienced. And they have hundreds of cases. They are going to sniff out a bad argument. You know, if you don't, if you're not the proactive problem solver who's thought this through and has the evidence to show, you're just going to be deemed as obstructionist and demanding, and without the adequate explanations. Again, putting these kids first. If you've thought it through, and I tell this to people all the time, like, if something isn't good for your kids and you want to show that you're a good person, how about you cede some time to the other person or make a concession because you can't be around on that particular day? Show that you're accommodating, be proactive about it and say, oh, by the way, in 3 months, I have to take this business trip. I'm just letting you know. Can you cover that day? And I'll do this for you. Even if you truly from your heart don't feel it and you're interested in presenting yourself in a better fashion in court, do it anyway.
Right. So
But
show
hopefully you
that
have
you're
good intentions.
flexible. Yeah.
Right.
Yeah. Okay. So I know we're almost out of time. Last little, well, kind of big question. So I showed you the book that just came out that we did when your ex turns the kids against you. And I told you that this is a big thing with many of our clients. And I think you also said that you see this a lot. Is there any way, knowing that this happens often in these high conflict cases where kids are kind of used as weapons, where they're supposed to show loyalty more towards one parent, is there anything that people should be thinking about when putting an agreement together to mitigate this from, or not even an agreement, just finishing a divorce or separation to mitigate that kind of dynamic? Big question.
It's a big question, but let me take it in parts. Um, Number one, I love that you didn't use the word alienation. I love it, because it's a word that's explosive and means a lot of things. So, if let me start it by saying this: if there is someone who is so, in my opinion, mentally ill that he or she has no problem influencing a child, manipulating a child, um, deriding the other party to make the other spouse look bad. If someone is so set to do that, and because they have their own issues, it is extremely difficult to get them to stop. And I need people to understand that because their expectations have to be really clear. So I get this question all the time. He or she is saying all these things to the kids. And I said, okay, what makes you think that you can stop it? That's the first thing. And I know that sounds terrible, but what it does is starts to let people know that, okay, this is a problem. I need to read about it and understand it. There's so many great works about it. There really are. And I mean, even if you go back to the scholarly, the work, I mean, Dr. Amy Baker, Dr. Janet Johnson, read that stuff because these are your kids. You know, that's first. Second is if you're going to try to stop it, and you should, I think the only effective way is to present in court so that the other side hears it, the detrimental effects that behavior has in children. So, in other words, people don't often recognize the harm that it does to kids. We're told kids are resilient, they could handle it. And also, people don't realize what they're doing is manipulation. But if
Mm-hmm.
you start to show them the works and say, do you realize there's a 50% increase in in the incidence of anxiety and depression in children who are alienated? Do you realize that suicidal ideation goes up by 30-40%? If you start to teach them that, that's the only thing that could work. Are you going to get some order or some agreement that says, look, I could put in every agreement, Lisa, don't be an asshole.
Right.
How about that?
But how are you going to enforce it?
If I can get that provision in every one of my agreements, I'd be the best lawyer in the world, right?
Right.
But again, so you're not going to be able to put, and judges throw the children's bill of rights around and they say, oh, here are the 10 or 12 or 13 things you can't do. People that are at that emotional psychological stage where they don't give a shit enough that they're doing it anyway, they're not going to stop because some agreement tells them to. So I think you try to influence them with education. The most important thing, and I'm stepping a little bit outside of my role, but I encourage people to do the reading and do the research about it, is if your kid is going through it, learn how to empower your kid to handle it, right? So teach, the old saying, do I pave the road for the child, or do I, prepare the child for the road, right?
Mm.
You know that spouse who's standing behind and leering at them at a baseball game to intimidate them, that's the same spouse that may or may not be alienating. So you have a kid. Here's what do I do when dad or mom says that? I want you to do this. And more importantly, when they come home and they say, mom said this, don't ask 20 questions.
Right.
Don't put them under cross-examination, but learn the tools, see a great therapist, someone who has experience in this particular issue. How do you redirect a kid? How do you handle it? Because over time, when you empower the kid to handle it, it's like kryptonite. It doesn't work anymore. And that's what begins to protect the child from that emotional harm and also from any manipulation that they may feel. So I know those are two, you know, they're not laser focused remedies, okay? But over time, that is what's going to really help the family in empowering the kid, educating the parent how to handle it. And again, guys, don't expect the court to, they hear three things, she denies ever having said it. No one's got a recording. Judges aren't going to indict someone and nail them to a cross because some commentary that they're making. Everything has nuance, everything can be denied. So really, if you're looking to help your children, do the homework, do the research, speak to someone who's really good at this and start to empower your children so that it doesn't have an effect on them. I'm sorry I don't have a better answer to get people to stop doing it, but people sometimes never learn.
Yeah, so I think your answer is realistic. And I think, like you said, we always say empowerment through education. The more a person dealing with what's happening and why and what they can do about it, because just like anything else, you can't change that other person. But you
No.
can change the way that you respond to your child. You can teach your child how to self-advocate. You can involve all kinds of family systems therapists and other professionals who understand this. But just like you said earlier in this conversation, there's been many people, you're coming after thousands of others who have been there before you, and some have done things right, so you can learn from them.
And let me just say one more thing for your listener. If someone is alienating a child, if they are manipulating a child, right? How are you going to get them to stop in the context of a court proceeding? Are you going to say, okay, you get less time with the child, right? Because what is a court deciding? Legal custody, physical custody. Okay. How much time does a horrible person need to manipulate a child? Can they do it in 1 day, 2 days, 3 days? Decreasing the amount of time that spouse is with the child is not necessarily eliminating the problem.
Right, that's not the cure. But there's other things that could be helpful. So really it's about connecting the dots. Again, proactive problem solver. Your Honor, this is what might help, and here's another thing that might, but not saying do something.
Right. Educate yourself is the first and foremost thing. Read as much as you can on a topic. Understand how complicated it is because it's not that simple. If you really read about the phenomenon and how it's employed by certain types of people, there's a lot you can read about how to decrease the effect on the child. But again, it's outside of my lane. I'm not a mental health professional, but there's so much out there. So I encourage people who are dealing with it, and a lot of people are, read as much as you can about it.
Yeah. Well, thanks for taking all of this time, Gus, and going into a lot of detail. How can people find you?
Oh, my website, www.dimo law. Um, everything's there.
And are you
Appreciate it.
just in New York or other states?
I I am just in New York. I have consulted in custody cases in other states, but my practice, I'm only licensed in New York.
All right, great. Well, thank you so much. I am thrilled that we got to do this interview, and I really loved your article too.
Thank you. Thank
All
you for
right,
having me.
let's definitely keep in touch.
Yes. Talk soon.
Okay, bye.
Bye.